CPL quiz 4, number 1. This came out of 260.20. Which, if any of the following are correct? And the only one was 3, so the answer is B. A defendant must be present during trial of an indictment unless, after being warned, he continues to be disruptive. You have to be warned once and then continue after the warning to be disruptive. Then they can be removed from the courtroom, but it has to be after an initial warning and the conduct continues. Number 2, in general, which are true in the order of a jury trial. So, my dad used to say it has to go in your head like a movie. So you have to see what happens. If you haven't been a clerk in the courtroom or an officer in the courtroom, this is not something that you're going to just know without trying to memorize it. So the way it works is the jury is first selected and sworn. The court delivers preliminary instructions. The court must. The people must deliver an opening address. Now, why is that a must? Because the people must tell the jury what they intend to prove. All right, number 2. This is out of 260.30, and which are true regarding an indictment jury trial. So we're in Superior Court. There's been an indictment by a grand jury. Now we have a petit jury, trial jury. You've never worked in a courtroom the same way I had never been inside a courtroom to see anything happen when I took my one test. So all this stuff I had to go and memorize step by step, and if you haven't memorized the order of the jury trial, what happens, then they can't trip you up on the question. So I'll try to give you a, quick way to remember it. So everything for the defendant is always going to be a may in a jury trial. It's always a may. The people have 2 musts and 1 may. The court has all musts. All right. 1, jury must be selected and sworn. 2, court must deliver preliminary instructions. 3, people must deliver opening address. 4, defendant may deliver opening address. 5, people must offer evidence in support of the charge. 6, defendant may offer evidence in rebuttal. 7, the defendant may deliver a summation or a closing argument to the jury. 8, the people may deliver a summation or closing argument to the jury. 9, the court must deliver a charge to the jury. And 10, the jury must retire to deliberate and, if possible, render a verdict. Okay, so this is different than in a non-jury trial of an indictment. The court must render a verdict, but in jury trials, the jury must retire to deliberate. I'm going to send you Dorothy's video on jury trials. Number 3, the number of peremptory challenges for each side in the trial of a B felony is 15. So B. D felony, you get 10. A C felony, you get 15, because remember, it's A, you get 20. B and C felony, you get 15. D, E felony, and misdemeanor indictment, you get 10. So 15 for B and C, and then everything else is 10 except for an A, which is 20. And then you get 2 challenges for each seat in a jury trial of an indictment. In a jury trial of an indictment, you get 2 challenges per alternate seat. 4, except for a charge of murder in the first, max alternates is 6 for an indictment trial. Number 5, which, if any of the following are true, and I'm going to read them all, but they're all true except for 1, and the reason that 1 is wrong is because a challenge to the panel, also known as a Batson challenge, is an objection to the entire panel of prospective jurors returned for a term. Cannot challenge a part of the panel. That's not the point of a Batson challenge, is to challenge the entire panel. 2, such a challenge may only be made by the defendant and only on the ground that there has been such a departure from the requirements of the judiciary law in the drawing or return of the panel as to result in substantial prejudice to the defendant. True. challenge to the panel must be made before jury selection commences. True. 4, such challenge must be in writing, setting forth the facts constituting the grounds of the challenge. That is true. It has to be in writing. So the way I remember this is I remember defense counsel like quickly scribbling his challenge on a piece of paper before anyone starts calling jurors. 5, the facts cited by defendant are denied by people. Witnesses may be called and examined by either party. True. 6, all issues of fact or law arising must be tried and determined by the court, and that is true. So the answer was B, everything except 1. 6, if no challenge is made to the panel or such challenge is made and disallowed, the court shall direct that the names of not less than D, 12 members panel be drawn. Another badly written. This is one of the things that really annoys me about the way the CPL is written. They have a habit of not being able to just state what the fucking law is. The court shall direct that this happens, or the court shall order something happen. And not just saying, like, if no challenge is made to the panel, or if the challenge is disallowed, not less than 12 names shall be drawn. Period. That's all they had to say, but that's like not the way it's worded, so it's annoying. 7, 270.15 continued. The examination of the prospective jurors shall be initiated by A. It's by the court. Okay, it's not by the DA. Even though they go first with the questioning, you think of them as going first. It's actually the court initiates the examination of prospective jurors. That's what it says. 8, which, if any of the following defects may an indictment be amended for? So an indictment can be amended for like stupid shit. Cannot be amended for legal insufficiency, failure to state a charge, anything that changes the theories of the prosecution. They cannot amend it for that. But names of persons can be amended. So the answer was C, 1 only, but I just want you to be aware that what it can't be amended for is like legal insufficiency, anything that changes the theory of the prosecution, a failure to charge an offense, a misjoinder of offenses, or a misjoinder of defendants. So the answer there was C for 1 only. 9, after a jury has begun deliberations, one of the jurors becomes unable to continue. And who has to consent for an alternate juror to be replaced? It's D. It's the defendant only. The defendant has to consent. Okay, who must be present during the jury's visit to the scene of the crime? And the only thing it says in the statute is the court. It's an appropriate public servant or something, and the court. Yes, the court reporter is definitely tricky because you think of it as part of the court and part of the trial, but the purpose of the visit to the crime scene is for visual inspection only. There's not supposed to be any talking. So that's why the court reporter is not required to be there. All right, 11. This is about plea of not responsible by reason of mental disease or defect. So this is to actually plead that. It's not raise that as a defense. We're talking about a plea here. So yes, you need permission of the court, consent to the people. DA must state that people are satisfied that that defense would be proven by preponderance of the evidence. Okay? And defense counsel has to state that in his opinion, defendant has capacity to understand the proceeding against him and to assist in his own defense and understands the consequences of the plea. And all of this is true. The reason number 4, you want to take note of that, is because if the defendant does not have the capacity to understand the proceeding against him and assist in his own defense, then we're in a different article. We're in 730 then. Then he's not even fit to proceed to the trial or proceed to plea. 12, which if any of the following must enter a plea by counsel? And the answer was B, 1 only. It's a corporation only. 13, John V. and Bob R. are to be tried jointly for an offense punishable by no more than 4 years in jail. So what does that tell us? That tells us it is an E felony charge. The number of peremptory challenges allowed to them is A, 10, because you do not get more challenges. It's the challenges are per side. So if there's 10 defendants, they still only get 10 challenges. 14. Bob, Vinny, and Bob F are being tried jointly. Bob H wants to use a peremptory challenge to remove juror Frank I, but Vinny C and Bob F disagree. In this case, his challenge, Bob H's challenge, should be disallowed. 15. Which, if any, are permissible places the sworn jurors selected in round 1 may sit during the second round of jury selection? And they can sit in the jury box, and they can sit in the jury room. They cannot sit in any seats within the courtroom, because if they sat in any seats within the courtroom, they might be sitting with the unsworn jurors. So the answer was D, 1 and 3, but not 2. And actually, the law also mentions that they can be allowed to leave the courthouse. 16, if a juror fails to appear or the court determines that there is no reasonable likelihood the juror will be appearing, within how long? So basically, how long is the court supposed to wait for a juror that is late? And it's within 2 hours of the time set by the court for trial to resume. The court may presume such juror is unavailable for continued service and discharge such juror. And also, yes, it's 2 hours here, but the court can also get rid of a juror that's late all the time, as long as deliberations haven't started. Then defendant would have to consent. 17, a motion for a mistrial may be made by, and it's all 3 of them, people, defendant, or court. 18, in the trial of an indictment after the jury is selected and sworn, the next step of the trial is A, the court must deliver preliminary instructions to the jury. Court must. Jury selected and sworn, court must deliver preliminary instructions, people must deliver opening, defendant may deliver opening, people must offer evidence, defendant may offer evidence. Yeah, make sure you have that shit memorized, because got to play that movie in your head of this trial. 19, upon a new trial resulting from an order declaring a mistrial, the indictment is deemed to contain, and it's all the counts, A, all the counts which it contained at the time the previous trial was commenced. There is a slight exception to this, I think. I have a very angry video about it, but on our test, they did not ask that complicated, hard-ass question. They asked, the basic question was that when there's a mistrial, the indictment has the counts that it had at the time the trial was commenced. 20, 270.30, after the last trial juror is sworn, the court may direct the selection of 1 or more, but not more than 6 alternate jurors. And if that wasn't a choice, you would have picked C. The court must deliver preliminary instructions to the jury. 21. After the trial of an indictment, the court, and the answer was B, 2 and 4, but not 1 and 3. So it's may, with consent of both people and defendant, discharge the alternate jurors. Just know the jurors have to be kept separate and apart from the regular jurors. The alternates are kept separate. 22. Before discharging a juror in a criminal case, the court must allow people an opportunity to be heard, must allow defendant an opportunity to be heard, and then must state on the record the facts and reasons why the juror is ill, incapacitated, or unavailable for continued service. So the answer was D. It's 1 and 2, but not 3 and 4. But the only reason 3 is wrong is because it said written decision. So it's just on the record they have to state that. But they have to give a reason. The thing to take away from this question is that they both get an opportunity to be heard, and the court has to give a reason on the record. 23. When 2 or more indictments against the same defendant or defendants charge different offenses of a kind that are joinable in a single indictment, the court may, upon the application of either the people or a defendant. So answer is B. Order that such indictments be consolidated and treated as single indictment for trial purposes. So when two or more indictments against same defendant or defendants charge offenses that are joinable, the court may, only upon, somebody has to make an application. The court can't do it on its own. Someone has to make an application and then order that they're consolidated for trial. 24. Upon request of counsel, any written or recorded showing concerning defendant's genuine need to refrain from testifying shall be ex parte and in camera. So that means the DA is not there and it's done in the judge's chambers. That's what in camera means. An ex parte just means it's one-sided, like one party. 25. Susan is on trial for a B felony. 3 alternates are going to be chosen. How many peremptory challenges may be exercised during jury selection? So looking for the max number here. All right, so let's do the alternates first because we want to make sure that we don't mix anything up here. So there's going to be 3 alternates chosen. That means the DA is going to get 6 challenges. Susan is going to get 6 challenges. So we know there's going to be 12 possible perempts just for those 3 alternate jurors. Okay? 12 because Susan got 6, DA got 6. Because you remember, you get 2 for every seat, alternate jurors for indictments. Now let's do the regular ones, and then we'll add that number to 12. So each side gets 15. That would be 30 total. So Susan got 15. The DA got 15. That would be 30. Plus the 12. Answer is D, 42. Number 26. Which, if any, of the following are grounds to challenge a prospective juror for cause? All right, this is a study question. They're all true. Fucking read them, please. 1. Doesn't have judiciary law qualifications. True. State of mind likely to preclude him from rendering an impartial verdict. True. 3. Related within 6th degree by blood or marriage to defendant, the witness, counsel for people or defendant, or he was a party adverse to any such person in a civil action, complains against such person, or bears some relationship that's likely to preclude him from rendering an impartial verdict. 4. Witness at the preliminary examination or before a grand jury or as a witness at the trial. 5. Served on the grand jury which found the indictment or served on a trial jury in a prior civil or criminal action involving the same incident charged in such indictment. 6. The juror has opinions about the death penalty, which actually does not exist in New York anymore. I better have won my damn challenge on that because they did put a death penalty question on it. 27. All issues of fact or law arising on the challenge for cause must be tried and determined by the court. If such challenge is allowed, the court must exclude the challenged person from service. So the answer is A. 27, answer A. 28, true or false? Every trial of an indictment or an SCI must be a jury trial. And that says, except as provided in CPL 320.10, and that is true. Now, I don't care that the book does not say SCI in it, because if you look at one of the earlier sections where they describe what an SCI is, I think it's in 195. It says somewhere in there, or somewhere in the CPL, it says every reference to an indictment includes a superior court information. 29. If a discharged juror was a foreperson, the court shall designate as the new foreperson the name that was drawn second and called. Okay. 30. A peremptory challenge is an objection to a prospective juror for which no reason need be assigned. Upon any peremptory challenge, the court must exclude the person challenged from jury service. 31. Which of the following statements are true regarding a protective order? Regarding disclosure of the business or residential address of any prospective. What's up? Good cause must be shown. So that's That's true. So good cause must be shown, and good cause is defined in question 32. 2. Counsel for people or defense are not covered by the order. That's true. So even if there is a protective order, it does not apply to people or defense counsel. It doesn't apply to either of the attorneys. So as officers of the court, they're being trusted not to disclose it to the defendant or any witness or something. 3 is wrong, but I'm going to make it right when I read it to you. A motion for a protective order may be made by the people, defendant, or any affected person, or sua sponte. So court's own motion, people, defendant, or any affected person. So that's why the answer was D, 1 and 2 only. But 3, if you want to make it right, cross off the word only, and it would read that a motion for a protective order may be made by people, defendant, court, or any affected person. Number 32 is true, and good cause is defined as the court determines there's a likelihood of bribery, jury tampering, or physical injury or harassment of a juror. Likelihood of bribery, tampering, injury, or harassment. 33, this is true. Every trial of an indictment must be a jury trial except as provided in CPL 32010. 34, after both parties had an opportunity to challenge for cause, the court must permit them to peremptory challenge any prospective juror, and such juror must be excluded. People have to go first, and they may not, after defendant challenged his people, then start trying to use challenges. And that does not work like that. And it is reversible error in certain circumstances. So this next one I'm going to do right out of the statute because it's worded in what I consider a little bit of a confusing way. It says, if either party so requests, challenges for cause must be made and determined within the courtroom but outside of the hearing of the jurors. And then it also says in that sentence that peremptory challenges must be made within the courtroom but outside of the hearing of the jurors so as not to disclose which party made the challenge. Now that is not necessarily what happens. If you have worked in a courtroom, you know this, but that is what it says in the law, that the challenge discussion is supposed to take place inside the courtroom. Inside the courtroom, just not in front of the jurors. Number 36, I actually don't know the answer to that question, so I'm going to have to do that on the next review. Now, what I like to do now is go over some of the principles that were in this quiz that maybe didn't get a ton of detail. So the first thing I want to go over is in 270.15, talking about what happens right after the names of not less than 12 jurors are drawn and seated in the jury box. And it says they shall immediately be sworn to answer truthfully questions relative to their qualifications to serve as jurors. Then the court may require them to complete a questionnaire about their occupation, where they live, prior jury service. You know the questionnaire, but that's a may. They don't have to complete the questionnaire. An official form for the questionnaire shall be developed by, guess who? The fucking chief administrator in consultation with the administrative board of the courts. So we got a shall immediately be sworn, so the not less than 12 names put in the jury box, drawn and called the way the judiciary law says. Then they shall immediately be sworn to answer truthfully the questions, and the court may require them to complete a questionnaire, and the court shall initiate the examination of prospective jurors. Then the people go, then defendant can ask questions if they want, etc. Then they let the people challenge for cause, defendant challenge for cause, people peremptory challenge, defendant peremptory challenge, and then the remaining names that are not excluded shall constitute the jury. So they must be immediately sworn in as trial jurors, immediately. Remember, the thing with the protective order, that could be a motion of people, defendant, court, or any affected person. When two or more defendants are tried jointly, they're treated as a single party. So if like 5 defendants are being tried for a D felony, they still, all of them have to agree on 10 peremptory challenges. And if a majority, let's say 3 out of 5, want to challenge someone, it's allowed because it's a majority rules. And if there's no majority, it must be disallowed, the challenge. Okay, viewing of premises with the jury. It's the court and an appropriate public servant chosen by the court. So the court actually gets to pick which court officer they want to take, in theory. And the defendant, defense counsel, and the prosecutor have the right to be present, but they do not have to be present. And it's to permit visual inspection only. And the court can order this at any time prior to summations. So it's at any time prior to commencement of summations, aka closing arguments. Any time prior to commencement of summations, the court can direct a jury viewing of premises, and it's for any material factual issue being helpful for the jury to decide, and visual inspection only. No one's allowed to engage in discussions about what is being observed. Okay, motion for mistrial. The indictment is deemed to contain all the counts which it contained at the time the prior trial was commenced, regardless of whether any count has subsequently been dismissed by the court.